I'm not gonna say full name. Keyvonte Clark.
All right. Good morning, Mr. Clark. How are you?
Good, sir.
All right.
I'm blessed this morning. I woke up.
All right. Amen to that. Okay. Oh. All right. All right. That's you, Mr. Macklin, and Miss Lisa Lindsay. All right, Mr. Clark. This is case number 250-570-7501. Precinct Michigan versus Keyvonte Clark. Appearances, please.
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan, P number 39570.
And thank you. Good morning, Your Honor. Good morning to your staff. Amir Macklin representing Mr. Keyvonte Clark, P76306. And Judge, for purposes of arraignment, we'll waive formal reading, stand mute to the charges.
Okay. Ms. Lindsay, can you restate your P number, please?
39570.
76306.
76306, correct.
Okay. You said you waiting for a reading, stand mute?
Yes, Judge.
All right, the court will not guilty plea on behalf of your client. Ms. Lindsay, what is your bond recommendation?
Your Honor, the people are going to be asking for a remand in this case. The defendant is charged with first-degree premeditated murder and mutilation of a corpse. The facts of this case are fairly gruesome. The defendant shot and killed a young woman and disposed of her body. Her body still at this point has not been found. The defendant has a criminal record. He has using a computer to commit a crime. He also had a reckless driving causing serious body impairment. He also has a contact for 2017 for an assault with intent to murder, which was dismissed at trial because the witnesses have failed to appear. But I would like to let the court know we will be resurrecting that case. And he is when they arrested him, it appeared that he was operating a chop shop out of his backyard, and they are going to be investigating that case and potentially submitting a warrant on that case also. For those reasons, Your Honor, due to the nature of the pending charges, I think a remand is in order.
Did I lose the court?
No, I can hear you. Go ahead.
All right. Thank you, Judge. Respectfully, Your Honor, I'd ask the court to grant reasonable bond pursuant to 6.106, and that governs the pretrial release. Judge, this is a cold homicide allegation. It stems from a missing person report of 2020, and as Ms. Lindsay has indicated, the body has never been found. So that leads us to believe that the very foundation of the criminal charge is in question. That's the corpus delicti rule. The evidence in this case is going to be very weak. It's based off of informants or people who don't have much credibility in terms of how this happened. They don't have any forensic data from my understanding or evidence, and there's no body, and I don't know about these eyewitnesses either. Mr. Clark has substantial ties to the community. He has a long standing connection to this jurisdiction. He has family here. He's employed. He owns a trucking company where he also owns property as well in the city of Detroit. He's lived here for decades. And despite knowing about this cold case investigation for years and being a suspect of it, he hasn't fled the jurisdiction. His criminal history does tie from a reckless driving causing serious injury. Ms. Lindsay has referenced uncharged cases, and I don't think the court should give any weight to cases that haven't been charged and cases that have been dismissed. And he has another case involving a computer, which was a felony. The severity of this current offense is the most extreme. It's severe, but the severity alone is not dispositive, Your Honor. So we look at the weight of the evidence. It's extraordinarily weak in this case. The lack of the body undermines both the probable cause and a likelihood and conviction in this case, which should favor some reasonable bond. I don't think that he poses a flight risk, as a result of him being engaged in this community, not fleeing the jurisdiction despite knowing for a number of years that he was the target of an investigation involving a homicide. And it's important to note that this case has sat dormant for years. The witnesses in this case were interviewed in 2021, and the case was only brought now. And so that should lead to some of the question mark as to what's going on with this case and where the underlying facts are. But I do believe that this court can set some reasonable conditions, and whether it be a high cash bond or a bond, with a GPS tether, we wouldn't have an objection to that, Your Honor.
Your Honor, the defendant's hubris in thinking that he got away with a murder, and his hubris in thinking that he had successfully intimidated witnesses not to come forward is no reason to reward him. As to counsel's allegations that the case is weak, seeing as how he has not reviewed a single bit of discovery in this case, that is baseless. We do have some evidence in the form of, for lack of a better word, GPS tracking and things of that nature that support the statements of the witnesses. For those reasons, Your Honor, I'm going to ask the court this is a first degree murder, and in the cases where the proof is evident and the presumption of a remand is in order, I'm going to ask for a remand at this point.
All right, the court haven't heard argument as to bond in this matter. First, I want to address two issues. First, Mr. Macklin, you alluded to the fact that due to the time it takes for the charging and that the body has not been found. Typically, murder cases oftentimes take years to investigate, as you well know. This is not CSI or television crime dramas where they're solved in a half hour or an hour. And so oftentimes they get leads, there's DNA oftentimes. And so it's not uncommon for homicide cases to take years. And to your also point, Mr. Macklin, the court will not take into consideration any charges that have not been filed against your client. So the court would not factor that into the bond consideration. All right, now as far as you, Ms. Lindsay, it is well noted that there's circumstantial evidence, and I believe there is a presumption of guilt in this matter, notwithstanding that a body has not been found. I think it's conjecture on your part, Ms. Lindsay, to claim that it was hubris on his part, and I don't know, because the court doesn't have any facts to that he's intimidated witnesses or anything. I would not take that into consideration of bond in determining a bond. I think that's all conjecture at this point, because there's been no evidence to the court with respect to that claim. But nonetheless, the allegations are very, very serious. This is a circumstantial case. I believe it's a relatively strong circumstantial case. And under MCR 6.106, I will remand Mr. Clark into custody of Wayne County Jail while this case is pending. Probable cause will be April 24th in front of Judge Jefferson. Preliminary examination April 29th at 1:45 p.m. in front of Judge Jefferson. Is there anything else either counsel wants to put on the record?
Yes, Your Honor. Is there a way you can notate for the file that it will be a notice of a long exam? So they can
what is long? What is long, Ms. Lindsay?
Right. That's right. A couple
That's
days.
a relative term.
It's going to be more than 1 day of testimony, one full day of testimony. I can tell you that. And I think counsel he's going to have to bring an external hard drive to get his discovery, because the discovery is so voluminous that it cannot be given over evidence.com, which is the usual way we give discovery. He's going to have to bring an external hard drive in order to get the discovery.
That's fine.
So
I'll call Miss Lindsay, Your Honor. That's fine.
At least 1 full day of testimony.
At least, Judge, and I'm being optimistic saying that we can get it done, but more than likely probably a day and a half, maybe 2 days.
Okay. I'm putting a note on the file, but I would recommend to both of you all sometime next week to contact Judge Jefferson to let her know.
Yes, Your
on in April that to block out some time for that court date, okay?
And could you give me those dates again for the probable cause conference?
Probable cause will be April 24th, preliminary examination April 29th at 1:45 p.m. on April 29th.
Thank you, Your Honor.
Thank you.